Are you ready?
You got it.
Welcome to the Ceremon Valley Democratic Club. My name is Brody Hilp. I serve as president, and I'm here with Rick Adler, our vice president, and Cecilia Manalga, our board member and Zoom administrator. The Ceremon Valley Democratic Club has many priorities. The most important is to support and elect Democratic candidates to local, state, and federal offices. Since our federal and state representatives are Democratic, we primarily focus on local candidates. And where do we get our money for contributions to campaigns? From our dues. So to become a member of the club, you must be a registered Democrat and pay the dues of $20 for an individual, it's very low, and $45 for a couple. And with those dues, we give campaign contributions to Democrats running for local elected offices. So please consider becoming a member. Your dues help Democrats get elected. And the easiest way to pay is through the website, Act Blue, and see the chat for the link of our Act Blue website. At our last meeting, we were organizing to march in Danville's 4th of July parade. And 7 of our members marched holding our 2 banners. We have a 9 by 4 foot banner, which read Ceremon Valley Democratic Club. And the second banner is a 7 foot wide banner that says, "Get big money out of politics." And the streets of Danville were packed with people, sometimes 10 to 15 people deep. And we received a good reception. Yes, there was some opposition. About 3 lone people shouted, "Go Brandon," which is a derogatory comment on Biden. But just 3 individual people did that. Our group was continually whooping and shouting our glee, so we just drowned out all those derogatory comments with our yells. And most of the other people, as we passed by, had huge smiles when they saw us. In fact, there was one group with 15 to 20 people who applauded us and shouted their support. As we marched the entire parade route, it's about 1 mile, there were smiling faces and thumbs up the entire way. It was very positive. And after the parade, we gathered for lunch on a beautiful patio and enjoyed catching up with each other. After COVID, we hadn't seen each other in person, and we were relaxing and talking for more than 2 to 3 hours. It was a wonderful day. Consider joining us next year. Okay.
Yeah, thanks to Karen and Steve Beck for that.
Yes, our members, yes. And we need to keep the Congress Democratic. There are very important elections across the country. We need to keep Mark Kelly, a senator from Arizona, Catherine Cortez Maestro as a senator in Nevada, many more, and there's so many opportunities. There's, if you don't like canvassing, there's phone banking, there's texting, there's postcard writing. And so, but also those people, in fact, our board member, Cecilia, regularly goes to the Central Valley each weekend and canvasses door to door to switch some of our congressional districts here in California from red to blue. So to learn about how you can help, go to ContraCostaDems.com and see the links in chat. We also hopefully will have some mobilized links for you also, so you can sign up. You know, in California, the November 8th election is just 3.5 months away. At the county level, we will vote for county clerk recorder. Vicki Gordon and Kristen Connolly are both running. They're both Democrats, and they have spoken at our meeting before, but we will have them back to speak at a future meeting. And did you know that there are elected positions that you can run for? And if you'd like to run for an elected office, the deadline to file your candidacy is August 12th. In some cities, it goes to August 17th. So to see more important dates, go to Coco Vote. The website is in chat. And 2 Danville Town Council members are up for election, Robert Storr and Karen Stepper, and both are not registered Democrats. And we would love to see Democrats running for these positions. The Democratic Party will help you with your campaign if you're willing to run, so please consider it. And our school district, the San Ramon Valley Unified School District, has 3 openings. One is Rachel Hurd's seat. Rachel's wonderful. We endorsed her in the past. She is in Area 5 of the school board district. And then also in Area 1, Ken Mintz is not running again. So that one is open. And Susanna Ordway is in Area 4, and that's also open. But one caution you need to know about. There are 2 new candidates who are on the fringe. They think that the school board's policy for masking lasted too long. They are running in areas 1 and 5. And actually 1 is a registered American Independent Party. So please be aware of the candidates you are supporting. For information on this, you can also go to the Facebook group, Parents of the San Ramon Valley Unified School District. And we will have the Democratic candidates for school board come to speak to us next month. Rick, would you like to tell us about the San Ramon City Council?
I just did.
I know, but this is our recorded meeting.
Oh, all right. Well, we caught me off guard there. We've got 2 district positions that are open, and we also have the mayor. And we've already discussed the fact that Sarah LaShanlo is running for District 2 and District 4, I believe, which is our own member who is running for mayor, is also, that seat is going to be up, and I'm not even sure who's running for that seat, but we've endorsed those 2 people, and we are looking forward to supporting those candidates in the general election. So we can never let down our guard too long. We've learned the hard way that is true. So anyway, that's what's going on in San Ramon. We've got the mayor and 2 city council seats that are up in District 2 and 4.
And at our 6:30 to 7 o'clock business meeting tonight, we just endorsed Sarah LaShanlo, and we also voted to contribute $1,000 to her campaign.
Right.
And she'll be speaking later on in our meeting.
Exactly.
And now we're ready for our speaker tonight. We have Dr. Katherine Florey here from UC Davis, who will speak on the Supreme Court decision, Kennedy versus Bremerton, which deals with prayer in public schools. And Dr. Katherine Florey graduated summa cum laude from Harvard University in 1993. She attended UC Berkeley Law School, graduating first in her class in 2004. She served as a law clerk to the Honorable William Fletcher, Ninth Circuit Court of Appeals. And she joined the UC Davis faculty in 2007 as the Martin Luther King Jr. Professor of Law. Thank you, Dr. Florey, for being here tonight.
Thank you for inviting me, and I really appreciate this group and all the good work that you're doing. I'm going to be talking a little bit about Bremerton. I will start just by sort of introducing the case and talking about some of the basics. Is it okay if I use some slides for that?
Yes, I think Cecilia has made you co-host, so you should be able
Oh, okay. All right, great. And then, I'm happy to open it up for questions and discussion. I know Brody shared a little bit about some of her personal experiences with me, and, this is an issue that I think we all have perspectives on, maybe based on, our experiences of religion in schools. So I'm happy to facilitate that discussion as well. So I just have some pretty basic slides. I don't want to, go into too much detail. But basically, this is a case about, balancing various aspects of the First Amendment. The First Amendment contains the Establishment Clause, saying that Congress shall make no law respecting the establishment of religion. That was originally applied just to the federal government, just to Congress, but it has since been held, all of the First Amendment, to also apply to state action. So it also includes, it governs what states and school districts, public entities can and cannot do. So there's this Establishment Clause, but there's also a prohibition on restricting people's free exercise of religion or of abridging their freedom of speech. And those two clauses, these are three distinct rights. Sometimes they're in a little bit of tension because, the government cannot endorse religion or promote religion, but sometimes that results in conflicts with individual people who may be part of government or who want to see the government, sort of ratify what they're doing, and they have their own religious beliefs, and those two things sometimes come into conflict. So that is sort of fundamentally what's at issue in this case. And I'll talk just a little bit. Sorry about that. I'm going to start by talking about sort of the factual history, the context. Interestingly, that's something that I think really, the two factions of the court, the majority and the dissent, really relied on the facts in very different ways. And there's kind of this fundamental disagreement over even what actually happened that is kind of unusual and interesting. There's also the famous Lemon test, which had been applied for really 50 years, off and on, to govern issues involving perceived government support of or entanglement with religion. And the Lemon test sort of fades away in this case. I'll talk about that. And then I'll talk about some of the tensions between, again, the Establishment Clause, the Free Exercise Clause, and to some extent the Free Speech Clause, and how the court resolved them. And then we can look a little bit at implications. So the basics here. This is a 6-3 decision with what's becoming this kind of familiar pattern with the conservative Republican appointed justices in the majority, and then the three more liberal justices in dissent. And of course, the liberals' ranks have been dwindling. So whereas, a few years ago we had a 5-4 court, 5-4 conservative majority that would even occasionally swing the other way, that sort of hardened to a firmer 5-4 majority. And currently, with particularly after Justices Kavanaugh and Barrett were confirmed, now it looks like a pretty solid 6-3 conservative majority. And the majority opinion is written by Justice Gorsuch, who's taken a real kind of particular interest in religion and the Free Exercise Clause. He's written in a number of these cases, and Justice Sotomayor in dissent, joined by the other two more liberal justices. So what is this case about? Well, it's about a school district in Washington State, kind of pretty close to Seattle. And there was a football coach in the district who, by all accounts, is pretty successful and well-liked. He, after reading a book about, kind of religious faith, he decided that he felt called after each game to pray on the 50-yard line. Initially, he did this somewhat privately, but students started asking if they could join him. He said, sure, it's a free country. So over time, this became much more of a big deal. Many more people participated. At one point, a majority of the team participated in this prayer following the games. Sometimes members of opposing teams or members of the public would also join in. So it became this pretty public spectacle. The school district got concerned because they have Establishment Clause responsibilities, and there's a line of cases that pretty clearly establish that any kind of organized school prayer as part of an official school event that's an Establishment Clause violation. And that's true even if it's at something like a graduation that students aren't actually compelled to attend, or even if it's something student initiated. There's one case where some students wanted to lead prayer over the school broadcasting system. And even though this was coming from the students, the court found that this was an Establishment Clause violation. So, the school district was on pretty solid ground here in worrying about what might happen and what kind of lawsuits might ensue if they allow this to continue. So there's kind of back and forth negotiations with the coach for a while. He did agree to stop, in addition to leading the prayer, he would also kind of make sort of motivational speeches to the members of the team after a game. And he was incorporating some religious elements into those. He agreed to stop doing that. He agreed to, kind of do this a little more privately. But he did insist on praying at the 50-yard line. And the last few times he did it, he also kind of reached out and announced to the media that he was going to do it. So again, even though this was a little less participatory, there were this time only a few people who joined him the last few times. It was nonetheless something that, did attract some public attention. And ultimately, the school district felt that, he sort of wasn't cooperating with their wish that this not be a public event. And so they decided not to renew his contract. He then sued, alleging that the school had retaliated against him for exercising his rights under the Free Exercise Clause. And this went through kind of several permutations, a couple different opinions in the lower courts. The Supreme Court sort of took a while before they actually addressed these questions directly. But ultimately, the Supreme Court decided this case and decided it in favor of the coach. A lot of what is, when you look at the majority opinion versus the dissent, as we'll see, sort of going through the opinion, there is this real just schism about how they see this case. The majority focuses on these three occasions where Coach Kennedy prayed in a somewhat quieter way anyway, or less participatory in any event. Whereas the dissent says, look, you can't just focus on those three incidents. You have to see this as, a guy who had a years-long history of incorporating religion, kind of into his duties as a coach. And you can't really understand this case without looking at that fuller context. So part of what's going on here is what you focus on, just these three kind of isolated occurrences or this larger pattern. And here's a picture of, sort of what it looked like with the coach leading a prayer. And as you can see, you have a lot of players, including some from the opposing team participating. And if you look at the dissent, they include, Justice Sotomayor includes a few photos like this, again, just sort of speaking to her general view that you should look at the context and, really kind of honestly represent what was going on here. So there are a couple main legal issues in the case. One is, this is kind of a preliminary issue that the majority and the dissent differ on both, but one question was whether Coach Kennedy was acting pursuant to his duties as a school employee or whether he was speaking as a private citizen. And generally, the case law says that if you are a public employee, then your employer can regulate your speech to some degree because you're essentially speaking on behalf of the government, not as a private party. By contrast, if you are just expressing your views as a public citizen, then the government needs to have a compelling interest. There's a strict scrutiny test if the government's going to abridge your speech or practice of religion. So a big question here was whether he's acting as a public employee or not. And I think this is part of where context comes into play. Again, majority focuses on these three times when he prayed kind of subsequent to being sort of reprimanded by the school district, where he did sort of take care to detach the prayer somewhat from his responsibilities to the team, like, giving them a pep talk after a game. And the majority says, if you look at just those instances, it was clear that he's expressing himself privately. The game is over and he's no longer fulfilling his duties as coach and so forth. The dissent wants to look at the wider context, that this is sort of something he took on as part of his role as coach. And you can't just kind of unring that bell, that it was clear that this was something he was known for doing. It was something in public. The dissent points out that he had duties to supervise the players after the game, so he wasn't off the clock. And he was doing this, at a school stadium, during the course of a school-sponsored event. So in some ways, even though that's sort of from the point of view of making new law, that's kind of a more minor part of the case, I think it really sets up the way the justices respond to these facts. So even if he was acting as a private citizen, in some cases, someone's free exercise rights can be sort of trumped by the government's need to comply with the Establishment Clause. That can be a compelling interest. So the majority had to go on and look at that issue. That brings us to the Lemon test. This is from a 1971 case. So, again, this has been in place for over 50 years. And in Lemon, the court set up this three-part test for determining sort of when government is excessively entangled with religion under the Establishment Clause. And this was a case, it wasn't about prayer in schools or anything like that, but it was about these two state programs where Rhode Island and Pennsylvania were they observed that a lot of parochial schools lacked the resources that public schools had. They came up with various ways of providing aid to them. The court said that both of these programs were unconstitutional. And this three-part test that the court announced said you have to look at these three prongs, whether the statute or government program in question has a secular purpose, whether its primary effect neither advances nor inhibits religion, and then it must not foster excessive government entanglement with religion. And only if it passed these three prongs of the test could the statute or other program be compatible with the Establishment Clause. So the courts had this test in place for many years. It's been criticized to some degree, as I'll explain. The court has applied it kind of inconsistently, sometimes applied other tests, sometimes applied a modified version. But it has this element of entanglement that's remained consistent. That tends to be the part that conservatives don't like, because it is a little fuzzy and doesn't necessarily give governments clear rules about what they can and cannot do. And I think they saw this as just sort of these kind of creeping establishment concerns that were taking over to some degree. But in some ways, the entanglement prong has also in some situations kind of helped religious believers to some degree, because the idea is that you don't want something that entangles government with religion to the extent of allowing the government to make judgments about what religious practices are acceptable and which aren't. So in some ways, this kind of protects the independence of religion. It's not just protecting government from religion, it's protecting religion from the government. Nonetheless, a lot of justices have disliked it, perhaps most famously the late Justice Scalia, who this was in 1993, I believe. So this was after Lemon had been around for a while, but, kind of midway through Lemon's history, Justice Scalia said, like some ghoul in a late night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again. So Scalia didn't like it, but kind of acknowledged that it was entrenched, that even though, he wanted to get rid of it, the court sort of kept bringing it up and applying it. And again, many years subsequent to Justice Scalia saying this, the court continued to rely on Lemon from time to time and never overruled it. Again, the court didn't always talk about it. It was inconsistent, but it was sort of a very accepted part of Establishment Clause jurisprudence. So one thing that's pretty remarkable about Bremerton is that the court just discards Lemon. It says the court long ago abandoned the Lemon test, which certainly is not true. And what's remarkable about this, really a couple things, but one is that when the Supreme Court does overrule a precedent, there's normally a long process. It's something that the court is hesitant to do, is very deliberate about, and the court is supposed to analyze various factors to decide whether a precedent should be overruled or not. And, whatever you think of the result in Dobbs, the court did go through that process to some degree. It went through an analysis of whether Roe versus Wade should be overruled and why. And the court just didn't do this here. It just said, look, we're not going to follow Lemon anymore. We're going to do something else. And it never even says it's overruling Lemon. The dissent actually characterizes the majority as overruling it. But, just as a matter of sort of legal methodology and practice, it's a very unusual thing to do. And, I think it's subject to a lot of criticism for not kind of going about this directly, for just kind of covertly overruling this case. So the other thing that's remarkable is that the court says in place of Lemon, we are now going to rely completely on historical practices and understandings when we interpret the Establishment Clause. So back to this very originalist view. But again, whatever you think of the merits of that, and I'm sure some of you don't think much of that approach, but whatever you think of it, what's really strange is that the court doesn't talk about historical understandings. It just, says that's the approach we're going to take, but doesn't really say anything about historically, how prayer in a public setting would have been regarded, what the Establishment Clause means, looking at the text. It really doesn't do that. It just sort of tosses off this explanation and then doesn't actually provide an example of how a court would go about that. So that's sort of how the court sort of sets up the law. And once the court gets into the analysis, it's clear that the court is really looking in a lot of ways to resolve this sort of historical tension between, on the one hand, the Establishment Clause, and on the other, the free exercise and free speech clauses, in favor of allowing free exercise. So this is a case that is really downplaying Establishment Clause concerns. And the court says, in justifying this, that all parts of the First Amendment have complementary purposes, not warring ones. So the idea is that there shouldn't have to be trade-offs between free exercise and the Establishment Clause. Well, that's, in some ways that's probably true, but in other ways, of course there are going to be situations if you have, you say on the one hand the government can't establish religion, but it also can't interfere with people's free exercise of their religion. That's always been regarded as potentially involving some tensions and trade-offs, just because if the government is going to be neutral toward religion, that means in some cases they are going to not be able to support people's religious practice. So, the court is sort of writing this off and saying there's never any tension between these two principles, I think really denies just a long history of the fact that they do sometimes point in competing directions. And by saying that this that there isn't this tension. What the court really seems to be doing is saying free exercise is more important, and so we're not going to pay as much attention to the Establishment Clause. And that's what the dissent really criticizes, saying, the court is paying almost exclusive attention to the Free Exercise Clause's protection while giving short shrift to the Establishment Clause. Another thing that the majority has to kind of sweep away a little bit in focusing so much on the Free Exercise Clause is that there are several cases, about half a dozen cases, that are specifically about prayer in schools in various contexts. And all of them say that you can't have prayer in a public school setting. This extends even to graduations, as I mentioned, where the argument was made, students aren't required to go to graduation, and the court is quite realistic about it, saying, look, no one's going to skip their graduation just because a prayer is being said there. So even though there isn't a requirement that students participate, there is this kind of social pressure and coercion in that way. And there's even this 2000 case that I mentioned about prayers at football games. And the court again said that this was impermissible under the Establishment Clause. It was a little different from this case in that this was not, just kind of one person praying and leading other people. This was over the public broadcast system. It was, I believe, done at the beginning of the game, so it's a little harder to avoid. But nonetheless, with some differences, in some ways it's a very similar case. And the dissent talks about it a lot. There's, I think, only one reference to it in the majority opinion, and it really just says in a pretty conclusory way, well, this case is different, and so it clearly doesn't apply here. But again, there's just not much in the way of explanation and not much effort to distinguish that case. Where are we going with this? I think that this is part of a larger trend in a couple different ways. First of all, I think you'll continue to see the court recognizing much more robust free exercise rights, and again, continuing to kind of resolve the tensions that exist between the Free Exercise Clause and the Establishment Clause by privileging free exercise rights. What's interesting about this trend is that the court has for some time been, I think, a little more receptive to free exercise cases, but you can see this accelerate as Kavanaugh and then Barrett joined the court. So each of those justices is much more conservative than the justice they replaced. And I think they, along with Justice Gorsuch, have kind of this particular sympathy with religious believers and kind of the public acceptance of religion. So they are really helping to push the court much more in this direction. And you can see this in a couple cases, one from 2000, where the court enjoined New York State from enforcing COVID restrictions on churches. And this was a situation in which churches were subject to restrictions that were very similar to those placed on other types of buildings like theaters and other places of kind of, public involvement or entertainment or performance. And the court in that case basically says that that's not the proper comparison group. If basically you're leaving any kind of building open, even supermarkets or the court mentions liquor stores or some medical offices, you cannot impose restrictions on churches that are any stricter than that. And what's striking about that case is that it came just a few months after Justice Roberts denied, or the court denied relief, and Justice Roberts wrote an opinion to go along with it. This is someone who, is one of the more conservative members of the court, but he decided to deny relief in that case. And, he wrote an opinion specifically saying that states should have a lot of latitude in this regard. what happens in the interim is that Barrett joins the court, and now there is this 5-4 majority, and the court, pretty immediately strikes down these very similar New York restrictions. And then actually the next spring goes on to strike down different California public health restrictions that the court thinks are too restrictive of religion. So, really vivid illustration of how things have changed. And then in another case decided in June of this year, the court finds, in a case again dealing with a state wanting to avoid establishment clause challenges and then running into free exercise problems, the court says that this tuition assistance program that Maine provides, Maine has a lot of rural areas where there isn't a local public high school. And in that case, Maine provides parents with, sort of tuition coupons if they want to send their child to a private school. And in Carson, the court said that Maine cannot exclude religious schools. So if they're going to offer these, they have to include religious schools as well. And again, this is the court kind of saying, look, free exercise is important, and it prevails over the state's concerns about not being, kind of too enmeshed with religion. So there's this trend very much in the free exercise direction, but I think there's also a broader trend going on here that applies outside the context of religion and the First Amendment. That is, this court, even though it has conservative views on a lot of issues, I think is really quite radical in some ways. It's the opposite of conservative in terms of its approach to precedent and prior practice and prior interpretations. There are some, thinking about the context of religion, there are a couple cases from several years ago, like Masterpiece Cake Shop, about the baker who did not want to create a cake for a gay couple, and Hobby Lobby about whether private corporations, have to provide certain forms of contraception. These cases had pretty controversial outcomes. Their outcomes were criticized. But if you read the opinions, they actually rest on really, really narrow ground. So the court was careful kind of not to decide more than it needed to. And even though, a lot of people were unhappy with the results, the court left a lot of current law intact. And I think a lot has changed now that Justices Gorsuch, Kavanaugh, and Barrett are on the court. They really do not have that impulse to preserve tradition. They want to do whatever they think, whatever they believe is right, without a lot of concern for precedent, without concern for kind of court traditions, and without concern often for consequences. Even if it's very disruptive to decide a case in a certain way, that's not something they seem to be taking into consideration. I think that's especially true of Justices Gorsuch and Barrett. It's also true of Justices Alito and Thomas, who have been on the court for a while, but now they kind of have a like-minded majority. And so you have this just kind of narrow majority of the court with Kavanaugh really as this swing vote that is just willing to upend precedent and traditional ways of handling an issue if that's what they think is the right result. So that's just kind of a brief summary of what I think is going on in the case, and I'm happy to answer questions or take comments.
If you have a question, we have some questions. Jillian.
Thank you. That was a really, really helpful assessment. I have a question about if we're talking about religion in school, and does that mean that, for example, like my daughter went to a private school, so it's a totally different piece, but we used to have in her school, there would be a discussion or whatever about Judaism, and then Muslim and Christian, and it was all a variety of religions. as opposed to Christian. And what are the implications of this ruling that if somebody is going to say we're going to have religion in school and that's okay, that it can be anybody can bring that to bear?
Yeah, it's a good question. And I think there are, one thing about this opinion, I think it's going to generate a lot of litigation as, people try to test what it allows. I do think the court remains clear, at least for now, that if it is part of the official school day, so if it's related to instruction or even if it's something that's going on during school hours, or even I mentioned the Santa Fe case, if it's something that went on during a football game even, then the court does seem to accept that establishment concerns preclude kind of overt promotion of a particular religion in that situation. So you can teach about religion if you do it kind of even-handedly, but, as of today, it's still not the case that teachers can decide, just to teach about Christianity or to otherwise promote Christianity during kind of official instructional hours, because there still is this distinction between an employee acting in their official role versus an employee who is engaged in some kind of private speech. That said, though, I do think there are going to be cases where if teachers praying in the cafeteria maybe, or, in some kind of public setting, maybe encouraging students to join them in the cafeteria, or maybe, getting together a group of students to talk about religion after school, that kind of thing, where the court's going to need to draw lines. And, I don't think it's entirely clear how those cases will turn out.
Thank you. I think it's, obviously one of the worries is that kids who are not Christian are going to feel very excluded. My daughter would be one of them. But also just the creeping of the rhetoric around that we're a Christian country. And this feels like a big step in that direction.
Yeah, I think that's absolutely right. And, a lot of people have questioned, and I think it's a really valid question, if this had been a Muslim coach praying, would the court have seen this the same way? And, I'm not clear that they would have. I do think that there's this kind of underlying assumption that sort of Christianity is okay, and it's sort of built into the fabric of our lives. And, I think if you had a teacher adhering to a different religion and being very public about it at a school event, I think some of the people who sided with the coach in this case might potentially see things differently.
Thank you.
Lynn Arscott?
Yeah, thank you very much for an excellent presentation. My question involves the Supreme Court and state courts too, but when you have these Senate hearings and they ask a question, senators say, well, what do you think about this, this, this? Very often the response, oh, I am going to look at the law and the facts. Well, all these decisions seem to come out 5-4, 6-3, and I don't think the law and the facts really have much to do with it. And I'm being a little cynical here, but respond. It seems to me the judges have a bias, judicial bias, and they decide what they think is right based on their own values, instincts, culture, whatever. And then they're so clever with the law that they'll cherry pick the law and the Constitution, whatever else, to support what they've already decided. So I think, to me, I'm absolutely convinced that's what happens. But my question really then boils down to, given, or if you accept that case, should we then have either shorter terms or more people expand the court so you dilute this extreme bias?
Yeah, I certainly think that, there have been various proposals to impose a 25-year term limits, which is obviously still a very long time and longer than the average time that Supreme Court justices served historically. There have also been proposals to expand the court to ensure that sort of presidents of both parties have an equal opportunity to appoint justices. It's not just a matter of chance. I would support both or either of those things. I do think just the role that luck plays in these very consequential decisions is really unfortunate. And, I also think that because, as you very rightly say, we all know that there's ideology at play here. It's really not fair for a president to be able to entrench their vision of what the law should be by appointing justices for more than 25 years. So I think those would both be very positive reforms. I think a lot of legal scholars think so. Unfortunately, and I even think that some people on the right, if they were dealing with this issue in the abstract, would also agree. But, right now they have the power and they don't want to give it up. So I don't see a lot of prospect of those kinds of reforms in the near future, but I think that they would be hugely beneficial.
Professor, oh, thank you.
Oh, wait, I think Chuck Carpenter had his hand up next.
Thank you, Brody. I do. My question is more on a local level. We have a movement in the eastern part of our county of people who don't like school boards that require masks, that want to control what's taught. And I can envision a time we have a majority on a school board, I really hope not, that will say we should have a prayer before the meeting. How does this decision impact a local school board?
Yeah, it's another good question, and it's I have heard that it's sort of a strategy to for people with very right-wing beliefs to kind of engage in activism at the very local level, particularly with school boards. And, I think this is one of the instances where the outer bounds of this decision are going to be tested. Again, as things stand now, if school board members are doing this as part of their public duties, then the Establishment Clause prohibits it, and Bremerton doesn't change that. So in terms of a school board, sort of having an official prayer or leading people in attendance in prayer is sort of part of the official meeting, that would still be prohibited. But, when you get into these line drawing cases where people can say, again, show up 5 minutes before the meeting and we're all going to pray and it's voluntary, I think it's a little less clear now if that's something that they can do or not. And, I think there certainly are people like the kind of people who you describe, who are going to be quite interested in pushing the limits. And if a case like that gets to the Supreme Court, I think they will find a fairly sympathetic audience.
Thank you. Thank you.
Thank you. Rick?
Yeah, Professor, I want, even though it's been a few years, congratulations on being #1 in your class. I mean, at Bald Hall, that impresses me greatly, having struggled through law school myself. So I like your analysis about the fact that the court in this case seems to put more weight on the free exercise clause. And you're saying that they really are not, I get the feeling they're not using strong arguments in a traditional, more conservative tradition where you value precedents and you really got to have a strong reason to overturn it. Do you feel like we're going to be coming into this same kind of analysis in the future where they're going to do what they want to do and maybe their legal arguments aren't as strong as in the past where something is overturned that's been around for many years?
I really do think that, unfortunately, and I think you just see such a difference if you look at, I think particularly Justices Barrett and Gorsuch just are coming from a very different kind of almost, embracing judicial activism, but in the service of, kind of more conservative right-wing ideas. And that's something, I think that you already saw with Gorsuch on the court, and now with Barrett, they have a pretty solid majority. The one kind of positive thing, I think Justice Kavanaugh is not, he's very conservative. I think he is a little more nervous, and sometimes you see signals. He wrote a concurrence in Dobbs, for example, that suggested, some limits on prosecuting people for leaving the state to obtain an abortion. So I think he's a little less ready to embrace just a total break with precedent in the past, but, he's still inclined that way to quite an extent. And coupled with the other four justices who form this kind of hard right-wing majority, there's just this increasing lack of concern with fitting cases into precedent, with ensuring that, kind of ensuring clarity in the law and lack of disruption. And I think that's something that we're going to continue to see, perhaps even more so in the future.
Thank you very much.
Yeah. Bob, did you have a question? You have to unmute yourself. Okay, there you go.
Okay, thank you. Thank you, Professor, for your presentation. I'm a retired public school teacher. Occasionally, we would have a prayer in school kind of issue. In the case of the football coach, and I used to say this to my students, I taught AP Gov and probably taught a lot of students like you when you were in high school. And prayer in school has never been denied. And Coach Kennedy's ability to pray never was denied. The question was when, because he said, when I read his comments, he said, I just wanted to go out to the 50-yard line and pray. I read his comments, and he could have went out, and I'm a former athletic coach as well. He could have went out to the 50-yard line 3 hours after the football game and prayed. When people would say prayer is denied in our school, I'd say, you haven't been in my AP government class. I'll bet you there's some kids praying right now as I hand them the exam. So being facetious and flippant about it, no one's free exercise has ever been denied that they can pray. The question is, and I don't know if the courts have ever addressed this, and you could help me out understand this. It's like it has to be public. When you just told me about the facts of the case, he had to do it publicly. And he had to be seen, and he knew, and if he went to the press and said, I'm going to do it at such and such, he had to be seen. And I'm a Christian, and I can go pray privately anytime I want, and kids can say the rosary in my classroom if they want. So no one's right has ever been denied. So I don't understand, has that ever entered a court of law in discussion about that?
Yeah, well, I mean, I think in some ways that's key to the case. So you're absolutely right. It's a very important point, that anyone has the right to pray privately, even in a school setting, or to, exercise their religion in other ways through what they wear or other practices. And the school district in this case, it is also true, never tried to deny him a private right to pray, and really didn't object to doing it on the football field, just didn't want all this publicity where spectators were participating, where there might be this pressure created to join in, where it just looked more like a school-sponsored event. Obviously if he's praying quietly, it's one thing, but if he's doing something and deliberately trying to attract publicity, it's very different. And I think the way the majority dealt with this was honestly not being fully honest about what was going on. And this was something that the dissent really tried to highlight by showing the photographs and so forth. The majority refers to this as private prayer and suggests that the school district was trying to interfere with that, but they explicitly didn't. They were fine with him praying. They just didn't want him to do it under these circumstances. And, as I say, the majority just deals with that by ignoring it, by mischaracterizing it, you could say, just to make this seem more like a private religious expression and not this sort of public performance.
Yeah, so it's a coercively persuading by making it public. It's really about control and about establishing a religion.
Yeah, I think it's about, to take the kind of cynical view of the court, I think there are a lot of justices who their own religion is very important to them, and they think that Christianity has, kind of deep roots in public life in the United States, and they're comfortable with a world in which that's true and in which the government is entangled with religion to some degree.
So thank you, Professor.
Thank you. I had a question. Well, actually, I have a comment. I wanted to share one of the experiences I had when I went to high school in Atlanta, Georgia. And this was in the 1960s. And this is how they got around prayer in school. So I think at that time, you couldn't pray in school. But what happened was during homeroom, the teacher said, oh, if anyone would like to bring their Bibles in, we can have the students you can come up and read a Bible verse, during homeroom. And so all these little Christian students in my class, they went up, from the back of the row to the front, and they would go down and they would bring their Bible in, and they would get to go in front of our class and read a Bible verse. But because it was, quote, student-led, even though the teacher encouraged them, right, and suggested it, because it was student-led, she felt that it was okay. So when it came time for me to bring the Bible in, and I didn't bring the Bible in, I'm not even sure where my Bible was at home. And so I think for 2 days, we did not have Bible verse, but then the next child came in and read the Bible verse. So how does, if it's not teacher-led, but the teacher encourages it, how do you deal with that?
Past cases, have said that even if it is student initiated and student led, that it's kind of about, is it sort of an official part of the school day? Is there an appearance that the school is sponsoring it or promoting it? And I think what you describe, clearly, even though it's not kind of an official practice, it becomes something that's a set part of the day, and it's something that students likely feel pressure to do. And I think that, one thing the majority opinion really ignored was that social aspect. The majority said, well, no student was required to participate in this or even asked to participate, and that means no coercion. But, we've all been in high school and, kids want to do what their peers are doing. They don't want to stand out. I think there is this subtle coercion, especially when you're on a team. You don't want to do something that's bringing your team together. You don't want to be the one who, sits out. I think that's just a reality that the majority just didn't grapple with at all. I think cases like what you describe are probably on the edge of what's going to be litigated now, something that maybe takes place on school grounds, but not during school hours. And, maybe the teacher suggested it, but it's mostly students who are doing it. I think that's a case that, 10 years ago, it would have been extremely clear that was unconstitutional, but now it's really not to such an extent.
Do we have any other questions? Well, Dr. Florey, thank you so much for explaining the establishment clause and all the other, I mean, it's just been amazing. So, and it's
Yeah, great job.
technical, and I feel like we now understand it a lot better. And so I thank you so much for joining us and talking tonight.
Thanks for inviting me and for the really interesting conversation and questions.
Thank you, Professor.
Thank you. I think what we're going to do now is as I had mentioned earlier, Dr. Dan Farber was not able to join us. He's traveling and he didn't have internet connection. But as our quote second speaker, we have one of our board members, Sarah Lashenlow. Sarah, did I pronounce your name correctly?
Yes, you did, Brody. Thank
Oh,
you.
it is. Okay, so it's Lashenlow. Okay. Okay. Sarah Lashenlow is running for San Ramon City Council District 2, and her opponent is a Republican, and we wanted to give her an edge to be able to say that she was endorsed by our club. By the way, Sarah, you were endorsed by our club, and we have awarded you $1,000 for your campaign.
Wow.
And why don't you talk and tell us about yourself, and tell us about, I don't think people know that you're an engineer. So,
Yeah.
So tell us about yourself and about your campaign.
I'd be happy to do that. Thank you, Brody. And before I start, from the bottom of my heart, thank you guys so much for this endorsement. It means a lot to me as a candidate, as a first-time candidate, as a grassroots candidate. This endorsement is more than just like something that goes on a flyer. It means that you're all standing behind me and supporting me. And I've learned the hard way that every dollar in a campaign really is very important. So these $1,000 that you are awarding to me just is going to revolutionize the campaign. So again, from the bottom of my heart, thank you. I'm a Democratic candidate, both in a capital D sense and a lower D sense. So I'm so open to hearing what you guys have to say, hearing if you have any feedback about my campaign, anything like that. But without further ado, if it's okay, Brody, can I share my screen? I have a little slide deck prepared. You're muted, but.
Cecilia, can you make Sarah a co-host? Yes, you're a co-host now.
Oh, perfect. Thank you so much. Okay. And before I get started, my internet's been a little spotty today. So if for some reason I pause or freeze, just let me know and I'll reconnect hopefully within seconds. But anyway, so everybody, I created a slide deck just to introduce myself to you more formally as a candidate for San Ramon City Council. And, I am a board member of the San Ramon Valley Dems as well, and that's been an amazing experience. So without further ado, let's get started. So I am Sarah. I live in San Ramon District 2, and I'm running for City Council, and I am running against an incumbent. He has never appeared on a ballot before. He was appointed in 2021. I also ran for that appointment. We both interviewed before the City Council together, and it was a great experience, and it fueled me even more to run for the seat when it came time. But first, before we get into the campaign, let me tell you a little bit about myself. So I graduated from California High School right here in District 2 in the year 2013. And I actually think that someone on this call was a teacher while I was there. And during the summers, I worked for the city in the Parks and Community Services Department as a recreation leader for Camp Central. So if any of you have kids or family members or loved ones that attended Camp Central day programs from the years of 2010 to 2015-ish, I was probably there, and they probably know me as Skittles because we all went by candy names. I then went on to Cal Poly and I got my degree in mechanical engineering. And I also worked on campus while I was there as a student shop technician. So I learned a lot about really learning by doing and, mechanical processes, wood shops, what have you. And then I graduated from Cal Poly in 2018, and now I work for a medical device startup company, currently remote, but we're a very small company of 6 people. We're working on postmenopausal health technology. So that's what I do in my day-to-day job, but I'm also really involved with San Ramon local affairs. As Brody mentioned, I'm a board member for the San Ramon Valley Democrats. I'm also the digital communications chair for the Tri-Valley Democrats. I'm also involved in a couple statewide initiatives, including Level Up California, which is a nonprofit, nonpartisan organization, but they also work to advance political initiatives through education, basically. And I also serve as an advisory committee member for the San Ramon Innovation and Technology Advisory Committee. So, yep, graduated from Cal High, graduated from Cal Poly, and this is a little screenshot of the City Council appointment interview that both the incumbent and I, as well as a couple of others, participated in last year. So as a City Council candidate, this is a very quick and easily digestible snapshot of my values and priorities. So these were defined by my, personal ethics and priorities, and also what I've learned volunteering and working alongside people in San Ramon over the years. So one of my top priorities is climate action, and I am by no means a single issue candidate. This is not the only thing that I care about, but it is a very important issue that has to be addressed on the municipal level. We can't wait for higher levels of government to do something about it. Frankly, the local government is so powerful, so impactful, and has a lot of tools at their disposal to make change in this realm. So currently the San Ramon City Council, or the City of San Ramon, has a climate action plan. It's nice, comprehensive. It took time and money to create this beautiful document, and it just went untouched and collected dust, and no one's talked about it. No one's touched it. No one's implemented it all these years. So the follow through has to happen, and in order for the follow through to happen, someone on the City Council has to prioritize it. I know that there are people on the City Council right now who do want to prioritize it, but they're in the minority. So I'm running to change that. Also, community safety is, of course, a huge priority of mine as a City Council candidate. One thing I value and cherish about San Ramon, which is one of the reasons I came back after graduation, is that this is a really safe, clean, beautiful, quaint, diverse community. And the thing, though, is that we want to keep it that way. And, times are changing and things are moving so fast, and we have to make sure to prioritize community safety in all of our development projects, etc., if we want it to remain the way that it is. And also, community safety, it means so many different things, right? We want to look at it with a creative lens. Community safety means, of course, having collaborative, productive relationships with, local law enforcement agencies, fire departments. However, it also means literally making sure that the members of your community are safe. It means making sure that dense housing developments are not right by whizzing cars, on busy streets. It means making sure that there's sidewalks. It means making sure that we can end preventable bike deaths in the East Bay, and etc. So conscious growth and city budget. We are growing as a city. We have a lot of development underway, some new housing, some new retail, etc. And it's important that we approach these projects mindfully and with also a very productive attitude. I think it's incredible that we're growing our city and giving people like me, young professionals who grew up here, an opportunity to potentially maybe even own something here in San Ramon, because right now, as it stands, a 4,000 square foot house is not something that, a young working professional even needs. So it's really cool to see that these developments are happening. However, retail and business is also leaving. Chevron is leaving, AT&T is leaving. So much of our revenue sources are leaving, and we have to make sure not only do we account for that and make sure that we as a city are still growing that revenue, but also that we're not losing an exorbitant amount of jobs. So it's a very important part of our local economy as well, is to maintain and grow the number of good jobs that we have in the city. Fourth out of fifth is local democracy. So democracy with a lowercase d. It's important to make sure everyone in the city is engaged with public affairs and votes in every election and has access to voting materials and knows how to go about it. There is already so much information out there about how to be an active citizen and how to be a good voter. But council members play a very big role in engaging their districts and reaching out to their constituents during, council meetings, voting processes, etc. I've never experienced any kind of contact by my council member, actually ever. And I think that needs to change. I think that people who live in San Ramon need to know the names of their city council members at the very least. And lastly, technology and innovation. So this is kind of a new and unconventional priority for a campaign. But the truth is that technology is growing. We're learning to rely on it for better or for worse for so many reasons. I'm on the Innovation and Technology Advisory Committee in San Ramon, and we're learning to embrace technology very strongly. And I'm really happy to see that we're moving in that direction. We're using technology to improve our traffic flow. We're using technology to potentially have citywide Wi-Fi at some point in the future. But it'll only go as far as our residents want it to. So there's a lot of, I think technology is new and it's different and it can be scary. There can be privacy concerns, etc. So what I want to do as a city council member is bridge the digital divide. There are people in this city who are unfamiliar and uncomfortable with the idea of technology playing a role in their municipal affairs. And that makes sense. I get it. That's fair. So it's incumbent upon the city council member to bridge that divide and engage with the residents and teach them about technology and maybe demystify some of the concerns that people have regarding technology. Because as a sitting member of the ITAC, we get public comment all the time about residents that are afraid of what all these technological measures are going to mean for their privacy. So not only do we need to acknowledge that people are feeling this way, but also actively engage with them and partner with them in assuring them that technology is only meant to make our city safer and more efficient, not the other way around. All right, so that's the philosophical, ideological part of my campaign, but let me also tell you a little bit about the logistics of my campaign. So there's, you can have the best ideas and still not run a good campaign. And I want to assure you all as endorsers of my campaign that we are working so hard in this campaign to make sure that we win. We have a great grassroots team of volunteers of all ages that either are here, that graduated from Cal High or that I've met through organizations like AAUW, etc., that are volunteering on my campaign. And they're in it because of the ethics and the values, and I'm really inspired by them. I also have a wonderful campaign manager. I've learned that you can't do this on your own. Delegation is power. And I have a campaign manager who is working alongside me. She's a fellow Cal Poly engineering alumni, and she's also not only has her master's in biomedical engineering, but she's also a project manager. So she's been applying Gantt charts to my campaign like crazy, and we have a really organized operation here. So we're running this race to win, And lastly, I have an amazing network of mentors. So many people on this call. I've pinged them. I've asked questions. I've had coffee chats with sitting elected officials, etc. So I'm really taking advantage of this amazing network of people that I have, and I'm learning a lot during the process. So it's really humbling and amazing to be a candidate for public office. And it's even better when you realize that those are the things that are going to actually help you be an electable candidate. Because electability just means people will vote for you. There's no magic behind it. So now I want to quickly walk you through my website, because hopefully you will visit my website at some point in the future, and I will actually drop a link to this PowerPoint in the chat later so that you have access to it. So my website is simple. It's sarahforcouncil.com. Can you guys still see the website loading? Can you see this? Thumbs up? Good. Okay, great. Thank you. So welcome to my website. It's meant to be easy to navigate, but also jam-packed with information. So one thing I'd like to highlight is that I want to be an accessible and transparent candidate, and I want to be an accessible, transparent city council member. So one thing that you or anyone that you know can do if they're interested in getting to know me better or providing any feedback is you are welcome to schedule a one-on-one Zoom chat with me. It connects straight to my calendar. You can snag some time, have a 30-minute virtual coffee chat with me, and you can access that link either through my homepage or through contact. And I have basically the slogan of my campaign. The building blocks that make us who we are also listed here. Listen, enact, impact. So I unfortunately, all too often, I see people who are lucky enough to hold public office not understanding like how much impact they have the opportunity to create. So they basically start and end here. They enact, then they sit back and relax. But enacting a law or a policy is only half of the fight. Then you have to follow through, make sure that these laws and policies are implemented in a mindful, good way. Make sure you keep adapting, make sure you keep iterating. And these are the skills that I learned going through engineering school, frankly, that I'm so surprised I don't see more like technological approach to politics, because it really is just problem solving, and I want to bring it back to that. My vision for San Ramon, and you can join my newsletter. A couple of other things I want to highlight. You can view, learn more about me up here. And there's a big button on the top right to donate, and we'll talk about that in just a second. But I am also really grateful to be endorsed by some really amazing people. I've been endorsed by the Run for Something organization. They're a national nonprofit. I've been endorsed by the San Ramon Valley Climate Coalition, as well as amazing individuals in the community and in California who I've connected with over the years. So that brings me to the last point of the slide, which is my ask for you. You already did an incredible thing by endorsing me as an organization. And for that, I really thank you. The next thing that I need immediately is to get 20 to 30 signatures on my nomination form. So if you live in San Ramon and if you live in District 2, I would love it if you signed my forms. It's not binding. It's not a vote for me. It's just so that I can get my name on the ballot. And if you're like, I don't know if I live in District 2, don't worry, you're in luck. On my website, under voter resources, I have hyperlinked a tool generated by the city of San Ramon where you can input your address and learn what district you live in. So it's so easy. It's very interactive. And what it looks like when it's fully loaded is this. So here's District 2, as well as 1, 4, and 3. And if you want to ever input your address, you just type it in right here, and then it zooms straight into the district that you live in. This is one of the first district elections that we're having in the city. So we're all new to this process. So it is important that you know what district that you live in. Only 2 districts are up for re-election this year. So anyway, please take advantage of this tool. If you live in District 2, send me an email and I'd love to stop by and have you sign my forms. The next thing that you can do is donate to my campaign. I don't know if you saw on my website, but I recently learned that in order to have a short candidate statement appear on the voter guide that's distributed by the county, I have to pay $861. And that's for my district, okay? Like the mayor or the mayoral candidates have to pay over $2,000 to appear on the voter guide. So in case you've ever wondered why a candidate doesn't appear in the voter guide, I always used to think it's because they weren't a serious candidate. I have learned that that is not true. It's because it's very expensive. I know someone who paid $12,000 out of pocket to appear on the voter guide as a candidate for county clerk recorder, and he lost, and he also did not raise that money back. So it's expensive, it's tough. And that's why every single dollar matters. So that's why it's important to donate to, candidates that you believe in. The next thing that you can do is, yeah, I know it's crazy. And the crazy thing is that when I was pulling my nomination papers, we were just having a casual conversation with the city clerk, and she's like, yeah, oh, yeah, $861. And I just had to like keep a poker face because $861. Okay. Well, anyways, the next thing that you can do is volunteer for my campaign. In about a month and a half-ish, maybe, we're working on the strategy. We're gonna want to start text banking and phone banking and canvassing in many ways, and writing postcards to send out to people in District 2. There are so many capacities you can get involved with my campaign. You don't have to like knock on doors and canvass if you don't want to. You can if you do want to. But there are so many ways that you can volunteer, and there is a volunteer interest form on my website. And you can also just email me. I will throw all of my information in the chat once this is over. And the last and most important thing that you can do is vote. I am considered a down ballot race. That means that voter turnout is already low as it is during midterm elections. It's even lower for down ballot candidates like me. So it's so important that you vote. And if you don't live in my district, that's okay. Vote for your district and then encourage your neighbors to do the same, because again, like voter turnout, unfortunately, it may be low this year. It may be high this year because there's so many crazy things going on, and there's Roe v. Wade and etc. And I hope that does invigorate people. But it's just so important that you vote. At the end of the day, that's the only thing that'll get me to office, is to vote. So that concludes my presentation. I'm going to drop a link to my website, my presentation, my email, everything in the chat right now, but I also want to open it to questions and comments, etc.
Anybody have any questions? I don't know, you're pretty thorough. You blew me away to know that it cost $861. I thought the county did that for free. I thought that was what they had to do for
Yep.
people. I'm just blown away.
I know we're actually lucky in San Ramon, and then I'm going to get to you, Bob. But we're lucky in San Ramon that we don't have a filing fee with the city. A lot of cities do. Yep.
Yeah.
And so there I was like, oh, phew. Oh no, wait, sorry. There's still an 861 price tag. Interestingly enough, too, I want to mention this because it's food for thought. That price is determined by the maximum number of words that you're allowed to put in your candidate statement. So my candidate statement now can be up to 400 words. It doesn't have to be 400 words, but even if it's 200 words, I'm still paying $861. Fun fact, the city council recently voted. It used to be some number less than 400 and greater than 250. So it used to actually cost less to submit a candidate statement, but several members of the city council recently voted to increase the word count, which therefore increases the price tag of a candidate statement.
Oh,
Yeah.
I see.
So
Okay.
yeah, so Bob, where did he go?
He's
Right.
Oh, there he is. Things flipped around. Hello.
Hi, Sarah. I want to ask you, why do you want to enter the world of local politics?
Good question. So I actually got started with my political involvement on the federal level. I was a volunteer for Citizens Climate Lobby, and I went to DC and I lobbied for a carbon fee and dividend on the Hill. And I realized there that like the needle moves so slowly on the Hill, and there's just like so much political wool that needs to start at home before anything can ever happen on the Hill. And that's when I realized that like what happens at home is so impactful because it starts the ripple. And then I started getting involved with local affairs, and I realized like so many things that we take for granted are actually touched and impacted by our city council. The parks that we like cherish here in San Ramon, the housing that everybody needs to literally survive, like every safety measure, every sidewalk, every bike lane, city council plays a part, and so does the city staff. So that was my federal involvement, and I interned with the state while I was in college as well. And So I've like gotten to kind of see several different lenses of politics, and I feel like if there's any entity that can set an example for the country, it's a city. You know, if we can't show municipally that like this, and this is possible, then I don't really expect DC to adopt it anytime soon. So that's really what inspires me to run for city council.
Great, thank you.
Yeah, thank you for the question. Rick.
Yeah, I had the pleasure of introducing Sarah last night to my local Rotary Club. And I like the fact that Sarah realizes that she's got to reach out to many different groups. And even though you might think, well, gee, she seems so young, but she's got the energy and she's wise beyond, I think she's wise beyond her years as far as knowing how hard it's going to be and what she needs to do to win. And I think your technological background is really good with this campaign, because that's how you reach out to many people. And I love your website.
Thank
And
you.
I look forward to helping you with the campaign, because I think you're an outstanding candidate.
Thank you so much, Rick. That really means a lot. And you've been so supportive since the very beginning. So I'm grateful to have you in my camp. Thank you.
You're welcome.
Chuck, it's nice to finally see your face.
Yeah, it's good to talk to you and look at you at the same time. Right
Yes.
now, I don't have questions. I have a whole pocket full that I will talk about later. I have two suggestions. There was just a candidate for Congress in Richmond who thought he had enough signatures, and he ended up not being on the ballot because some weren't valid. If you think you need 20 to 30, get 40 to 60. One of the really important things about signatures is voter contact.
Yeah.
If you think enough about me to ask me to sign your papers, I might even like you. And it's critical, critical, critical. I'm full of ideas, but that's one that you can't let get by. Another reason Sabina will pay 2,000 and you pay 800, she's running citywide.
Yep.
And on a more mundane level, it's how many they have to print.
Yes, exactly.
So it's not so much by the word, but it's by the booklet.
Mm-hmm.
So
Yeah. Mm-hmm.
both of those work. And remember, the ballot statement, 2/3 of the voters will never hear you, but they'll check out, who is this Sarah person? So it's critical, have many people read it, because no matter how good we all think we are, together we have more ideas.
Absolutely. You're right.
So thank you. Your presentation was great. The Ceremony Club is great to pay for that ballot statement and leave you change. And remember, mail, once you have it designed and printed, only costs 26 cents to send out
That's
per
perfect.
each.
That's
Okay.
perfect.
Thank
Thank you so much. I appreciate it. Thank you, Chuck, for all the input, and I'll probably be in touch with you at some point in the future, let's be honest. Brian, I see a raised hand.
You're muted.
I gotta find my microphone. It takes me a while. Thank
No.
you. Sarah needs to send me her contact information so I can get a check mailed to her.
Thank you so much. Yeah, I can also email this stuff to you, but I threw the address where I can like accept checks and stuff in the chat. So 231 Marketplace, number 138, San Ramon, California. But I can also follow up with you on all of that information.
No, I've got that information. That's fine.
Awesome. Thank you. And yeah, just to bring everyone else's attention to it, my website, this is a little confusing, unfortunately. My website is sarahforcouncil.com. not sarahforcitycouncil.com. Sarah for City Council is already taken by a lovely woman in Washington. And but my email address is sarahforcitycouncil@gmail.com. I know it's confusing. It's not optimal, but I'll just drill it home. sarahforcouncil.com. The link to my presentation also is in the chat, as well as my email and the address.
Are there any more questions? No? Sarah, we are so happy that young Democrats are running for office, and especially very intelligent, capable young Democrats. So thank you so much for stepping forward and presenting tonight. I hope it's great. We're going to work really hard for you.
Thank you so much. Your support means the world, and it's so nice to address all of you officially as a
But the
candidate.
incumbent was appointed.
So what, he's still on the.
Correct.
The incumbent was appointed last year.
Yes, I think I went to that,
You did.
session. Yes.
Yep.
Because it was a really big one that he was.
It was. There
Yeah.
were like 5 of us, I think, being interviewed for the appointment process, and it was an extensive 3-hour long. And it was also such a crazy day because it was on January 6th of last year. So like, imagine the heavy hearts, you know. But anyway, this has been so great. I'm really grateful for you all, and I see like through your facial expressions, even though we're all on Zoom and on mute, I like really am grateful for the support, and it's very endearing to see all these smiling faces. So thank you.
Yeah, thank you. We're all thank you all, everyone, for coming to our meeting tonight. We're going to try and have Dan Farber in the future. We have Eric Swalwell and Rebecca Barracan are going to be in the next couple of months. I'm not really sure exactly what months. And then also, we also need to have people speak about all the ballot measures. And so that's going to be a big, important meeting. Anyway, thank you all for joining us tonight. Really appreciate it, and enjoy your evening.
Thank you. Thank you,
Thank
Bird.
you all so